We've touched on 2 rules so far. Now let's get to the third rule. For the rule against misjoinder of offences, each offence should normally be tried separately in different charge sheets, especially when they weren't done in the course of the same transaction, making them unrelated. So this is a charge sheet based rule, not a count based rule like the last two. Now ACJA has provided for some exceptions to this rule. The first exception is offences committed within 1 year, provided by section 209A of ACJA. So any 3 distinct offences committed in the span of 12 months can be put together in the same charge sheet, but different counts. They don't have to be offences done in the course of the same transaction. This rule is to avoid multiplicity of suits and also to prevent paper wastage. So basically, if a person kidnaps in January, murders in June, and robs a bank in September, 3 offences distinct from each other, you don't need 3 separate charge sheets. Just put everything in one charge sheet but in separate counts since they all occurred within 12 months. Remember, in this instance, the offences must not be more than 3. The second exception, offences of the same or similar character. This is provided by section 209B of ACJA. So if, for example, a serial rapist has raped 100 people in the span of 3 years and committed similar sexual offences to 50 more people, he can be tried for all the rapes and sexual offences in a single charge sheet, but in different counts. So instead of 150 charge sheets, you have just one charge sheet with 150 counts. This exception is also to prevent multiplicity of suits against the same person. The third exception, offences committed in the course of the same transaction. This is provided by section 209C of ACJA. So if different offences were done, but in the course of the same transaction, then they can be tried together in one single charge sheet, but in separate counts. For example, criminal conspiracy, obtaining legal firearms, and armed robbery don't need to be in separate charge sheets since they are all part of the same transaction. Just put them all in one charge sheet but in separate counts. Fourth exception, offences falling within 2 definitions. This is provided by section 212 of ACJA. So if the ingredients of the offence constitute an offence in another law, they can be put together in one charge sheet but in different counts. For example, Section 35 of the Marriage Act prohibits a person married under the Act from pursuing any other marriage with another person. Section 370 of the Criminal Code defines the same act as bigamy. These 2 offences can be tried together in the same charge sheet but different counts. Fifth exception, acts constituting one offence but constituting a different offence when combined. This is provided by section 213 of ACJA. And what it's basically saying is that when separate acts are individual offences in their own right, but then when you combine them, they create a different offence, the individual offences, as well as the new combined offence, can be tried together in the same charge sheet. To illustrate this, we'll be looking at an excerpt from the OG storyteller, Professor Agaba. So if 2 dudes want to take over the federal government of Nigeria from the president, and in furtherance of that intention, they engage in military training, unlawful use of military uniforms, illegal possession of arms and ammunition, and unlawful destruction of property. These are individual offences in their own right. But guess what? All these overt acts constitute the offence of treason when combined together. And so all of them will be put together in the same charge sheet. Sixth exception, where it is doubtful which of the several offences the fact which can be proved will constitute. This is provided by section 214 of ACJA. It's basically saying that when you are doubtful of which offence the facts of the case will prove, you can put the several offences in the same charge sheet. This usually happens when the prosecution isn't really sure which of the acts will constitute an offence, so he just puts both in there. For example, from the facts of a case, it may be tricky to know whether the person committed the offence of stealing, or whether it was criminal misappropriation, or a criminal breach of trust. They have the same mens rea of dishonesty, but different actus rea. So instead of creating a separate charge sheet and trying them separately for each of these offences, you can put them all in one charge sheet, different counts. The court will then look at the facts of the case and decide which offence to convict the defendant for. So the court will simply stay the other offences and give judgment on one of them. Side note, the reason why it's proper for the court to stay the charge is so that it can still be addressed if the matter is appealed. If the court of first instance gives an order of acquittal, it's difficult to revive such a charge on appeal. And who knows, maybe it's that crime that the defendant is actually guilty of. There's another exception that was created by section 215 of the Repealed CPC, but it was not imported to ACJA or the ACJL, so let's skip that one. And that's it for the third rule, the rule against misjoinder of offences. The next one we're going to look at is the last rule, rule against misjoinder of offenders. Stay tuned. Thank you very much for watching my video. If you like what you just watched now, please like, subscribe, and share with your friends. Also, please feel free to hit the notification bell so that you get updates when my videos come out. Engaging with the content actually helps the algorithm see my videos, so I get to share it with more people. Don't worry, we'll be getting more content like this. Have a great day.